Yes, good evening to the prosper candidates of the JCJ 2022 main examination, and read what I posted on the screen. Anyone can unmute and read. Read what I posted on the screen so that I could know that you are with me and I am with you, and both are traveling in the same boat to reach the destination. Advocate, read. Unmute and read what I posted on the screen. Salma.
The transferability of the property is based on the maximum alteration if preferential jury as presently, which means law favors alienation to accumulation.
But you did not read immovable property is not transferable. That is the topic of today's discussion. And this transfer of the property is based on the maxim. Alienation re preferator jury accrescendi, which means law favors alienation over to the accumulation. Law never encourage accumulation. What will happen if the accumulation is there? Anyone? Give me the answer. If you don't know, you say pass on. I will give you the answer. Repeat. Why the accumulation law favors? Law will not favor. Please unmute and give me the answer. I told you, if you don't know, say pass on. Salma. Salma.
Sir, don't know, sir.
Say, I gave an option to you. If you don't know, you say pass on. The law favors always alienation, not the accumulation. What will happen if the accumulation would be there? Only the people, those who are on fingers, will rule the country. Number one. Number two, there will not be any revenue to the government because the property will not be transferred. When the property will not be transferred from one person to another person, where the government will get the registration fee and stamp duty. Are you following me?
Yes, sir.
And these are the property which we are dealing is immobile property. And immobile property, either you transfer in any form, it should be registered. Why? Salma, give me the answer. If you don't know, you say pass on. Naveen, you also.
Sir, pass on, sir.
See, if you read the Transfer of Property Act, there is one provision is there. If any property worth more than 100 rupees and that property is a immobile property, it should be
registered.
Repeat. Registered. Am I right? Say yes. So, that is the reason that we want that it should be there. In how many ways you can transfer the property? Anyone? How many ways a property can be transferred? If you don't know, you say pass on. Participants, did you hear my question? Speak.
Sale, gift. You can transfer the property by sale, by gift.
So 3 ways, sir.
What are they?
Sale deed, gift deed, and relinquishment deed.
Over. I appreciate, Naveen. At least you have given some of the mode. A property can be transferred in the at least 5 to 6 modes. But in the Transfer of Property Act, it is say only the 5 modes. Number 1, sale. Number 2, lease. Number 3, mortgage. Number 4, gift. Number 5, what is the number 5? Anyone? Sir, a property can also be transferred by the will, but the will not be covered by the Transfer of Property Act. How many ways? Now let us see that, because I don't know, there are I read it. There are 5 ways a immovable property can be transferred under TP Act. Because I don't know how I missed one. Number 1, tell me, is it visible?
Yes,
Is
sir,
it
it is
visible?
visible, sir. Yes, sir,
Read.
visible, sir. Yeah, visible, sir. Mortgage, gift, sale, actionable claims, and lease.
Read this portion.
The Act covers 5 types of transfer of immovable property. These are as follows: mortgage, gift, sale, actionable claims, lease.
Yes,
The transfer of property.
we missed actionable claims.
Yes, sir.
Because we dealt mortgage, we dealt sale, we dealt lease, we dealt gift. What we missed is actionable claims.
Actionable claim.
Do you know what is actionable claim? There is actionable claim is a non-tangible. We cannot touch it, because the claim is by the operation of law. That is say which you can say actionable claims. Okay, now let us see that, because introduction in the transfer of property is defined in the section 5 of the Transfer of Property Act. It is an act by which a living person, see the word say, a living person conveys property, means transfer the property, pass on the property in present or in future to one or more other living persons, or to himself and one or more other living persons. Again, the 2 living persons should be there. And to transfer property is to perform such an act. So one living person to another living person. What about the unborn child? Yes, it can be. Am I right? A mother's in the womb. Yeah, when the inheritance comes, no. Yes, definitely that a mother's in the womb. But of course, certain condition that the baby should be viable at least for 48 hours and so on and so forth. So the Transfer of Property Act 1882 contains the specific provisions regarding what constitutes a transfer and condition attached to it. Whatever the condition applicable to the contract, also applicable to the Transfer of Property Act. Am I right?
Yes, sir.
Good, I appreciate. The Transfer of Property Act 1882 is defined as an act by which a living person conveys, passes, transfers property in present or future to one or more other living person or himself and one or more other living persons, and to transfer the property to the perform such an act. The living person includes a company, whether incorporated, not an association, or not, or an association, means whether the company is incorporated or not, doesn't matter, or an association, or a body of individuals. That means juridical personalities. Am I right? Say yes or no.
Yes, sir.
Who are the juridical personalities? Gausia.
Sir.
Who are the juridical personalities? I told you, company, a temple, an association, or a club, and these are all body of individuals. So Section 6 of the Transfer of Property Act 1882 deals with that, what may be transferred. What property may be transferred is given in the 6, and what is transfer of property is given in the Section 5. It lays down the exception to the general rule. Before moving forward, it is important to know that the word property. Can you say what is meant by property? Anyone?
Any valuable thing, sir.
What are the kinds of property?
Movable property, immovable property, tangible and intangible property.
Actionable claims comes under which category?
It may be for both, sir, movable and immovable properties.
I said tangible or intangible.
CP Act actionable claim is regarding immobile property, sir.
It is a tangible or intangible.
Tangible, sir.
No, you cannot touch it. Only claim that you have it. Actionable claim. It is only the application. It is a right. So it's intangible. Please check it. Why check it? Now we'll make it very much clear. Actionable claims are tangible or intangible. Actionable claims are tangible or intangible. Why I am giving this thing? If you have any doubt, Mother Google is there, search engine. Read now.
Actionable claim is an intangible immobile property and it is transferable. It mainly refers to the types of claims that can be recovered through proceedings in courts.
Now you tell me, actionable claims are
Intangible immobile property.
intangible. I appreciate. Why we should not go with the doubt? Anyway, that's a clarification to me also, because I am also a human being. There is a Latin terminology is there. Errare este humanum. To err is human being. Is it clear? Say yes. So now,
Sir, what, sir?
yes, Gausia, you want to ask something?
Yes, sir. The maxim and the meaning, I didn't get it, sir.
You did not get it. Okay, don't worry. I am here to clarify it. Yes. I said, errare est humanum. I'll magnify or enlarge it so that you could see it. Is it visible?
Yes, sir.
Read.
Errare est humanum.
It is a meaning means, we'll make it very much clear to you. It means to err is human being. Yes, read. Read. Here both the ways are there. Errare este humanum or humanum este errare. Are you following me?
Yes, sir.
That means
To err
it
is
there.
human.
That means
To err is human.
to err is a human. Is it clear?
Yes, sir.
So don't miss my class. If you miss my class, you miss many things I told you. Not only the subject. So now let us come to the properties are different types: movable, immovable property, tangible, intangible property, and actionable claims under the intangible property. The word property has not been defined in the Act, but has been given in the wide scope, meaning and includes all description of the properties. And when the Act is silent regarding a particular word, then we rely on which Act?
General Classes Act.
General Class Act of, I think it is 1892, 1896, if I not be mistaken. Of course, you cannot remember all the names, but at least remember the name, General Class Act. And we have to take from it. The word property also covers both the tangible materials, such as the buildings. We can touch it, we can see it. Both we can touch and see is called buildings, lands, etc. And intangible materials such as a copyright, you could not see. And a tenancy, you could not see. Are you following me? Actionable
Yes, sir.
claims, you cannot see. In this article, the property is immobile in nature and are not transferable under the Act will not be discussed in detail. So now we will see that what is immobile property. Section 3 of the Act defines what is immobile property. Though the section is not exhaustive, it lists down all the things are immobile property which does not include standing timber. See, a negative way of giving the answer, giving the explanation. How all the things are immobile property which does not include, means standing timber will come under the movable property, growing crops come under the movable property, or grass comes under the movable property. These three items comes under the movable property. What are the three items come under the movable property? Anyone? Just now I read.
Standing timber, crops, or grass.
Yes, it is here standing timber and growing crops. Growing crops and the grass. What is the grass spelling, please?
GRASS.
Professor Hussain students never say like that. Anyone? Anyone? Priyanka, do you know how do you pronounce? Unmuted, say. If you don't know, you say pass on. Salma, you never use the word GRA. Repeat. Repeat.
GRA.
Yes, that is the Professor Hussain style. GRASS. So that is the way. In simple terms, immobile property is a property that cannot be moved. Section 3, you say what is this 26? Section 3,
Class 26.
Class 26 of the General Class Act defines immobile property as it shall include, they say it shall include land, benefit arising out of the land. What are the benefits arising out of the land?
Fruits.
Trees.
If trees are there, fruits will be beneficial.
Fisheries.
Fisheries also.
So anything benefits to arise out of the land and things attached to the earth. The things attached to the earth. Sir, what is land? What is the earth? Anyone? Please, if you know it, you tell me. If you don't know it, you say pass on. Don't waste my time.
Land is used for cultivation, sir.
Good.
Earth is for any purpose, whether it is for building purpose, constructions, any other purpose.
Earth is for everything. But land is for construction, playground, and airport. For some purposes, a land would be used over there. And where a particular construction could be made. And that's why we say land. And here things attached to the earth. తెలుగులో మట్టి అంటారండి. ఇంగ్లీష్లో చెప్పండి. Tell me in English.
Soil.
Pardon? Say loudly.
Soil.
Yes, we can also say soil, but we never say sand. But we don't say burada. Burada means
Mud, sir. MUD.
mud. But sometimes we will say gravel also. GRAVEL. Gravel, both the way comes it. Gravel becomes a mortar also, and sometimes earth and gravel they will say. Or the earth debris. Of course, debris is different again. Don't worry about it. So here we should know land is for certain purposes, but anything attached to the earth except for standing timber, crops and grass. And we already dealt it. That is clearly given in the Transfer of Property Act. Am I right?
Yes, sir.
Okay, the difference between the movable and immovable property, everybody knows it. The following is the difference between the movable and immovable property. Can I make it out or you know it? Yes? Can I explain it or you will make it out?
You please explain, sir.
Okay. First bullet. The movable property can be easily transferred from one place to another place without changing its capacity or quantity. See, the two words are given, capacity and quantity. It will not change. While an immovable property cannot be easily transferred from one place to another place, and if transferred, then it loses its originality and changes in the shape or capacity or quantity. See, now the cranes are there. Even cranes will pluck a big tree and plant in some other place. But it cannot plant the same way as it was natural. Am I right?
Yes, sir.
So that's why they said it originality and changes in shape and capacity and quantity. Now, and I don't know, everybody read the law of Tart. Am I right?
Yes, sir.
Tree. T-R-E-E, tree. Is it a mobile or it is a mobile? Number one.
As
Number
far as
two.
it is,
Number two, is it animate or inanimate?
as far as it is attached to earth, it is immobile property, sir. Once it is attached from the earth, from the land, it is a mobile property, sir.
What is the Salmon says? What is the Winfield says? There are two schools of thought.
Yes, sir.
And two schools of thought also write in their own perspective. And he say, tree is a immobile because it cannot displace from one place to another place. Is it clear?
Yes, sir.
And tree is a animate also because it will go vertically more and horizontally less. And another school of thought say tree is a movable property because it grow from a sapling to a shrub to a tree. Means growth is there and it is animate. So both are right in their own perspective. So that is the example we'll make it out when we are dealing. Law of Torts, T-O-R-T-S, Torts, R-T-O-R-T, Tort. Okay, next bullet. Okay, I will ask the one question. I would like to see that. Currency. Do you know what is meant by?
Yes, sir.
Rupees note, denomination, 1,000 rupee denomination. Is it a mobile property or immobile property? Or what do you say it is thing? Is it a goods?
It's not good, sir.
It is a mobile property.
Yes, sir.
Then what is the exact name? I told you when I was teaching the MCQ, I don't know whether you are present or not. We never say goods. We'll say things. Things. Is it clear?
Yes, sir.
Good. Appreciate. Next, the second word is the movable property is the property that is not attached to the earth, obviously, and it can be moved, definitely. For example, cars, books, etc. But if mango trees are cut and sold for the timber, then it is considered the movable property. In the case of the immobile property, which is attached to the earth and cannot be moved, example, building, trees, etc. But if your mango trees are sold for nourishment purposes and fruits, then it is considered as a movable property. So, if fruits are only sold, because you know, the mango grows, if any person is having over there, they will auction it. So the people, they will come and they buy it when it is a very small in size. So they cut only the mangoes and they will sell it, but they never cut the tree or trunk. And hence it will say buildings, trees, etc. If mangoes trees are sold for nourishment purposes and fruits, then it is considered as immovable property. Here, they take only as the fruits, make the drinks. Is it clear?
Yes, sir.
Say yes. See, okay, because the registration of the immovable property is non-mandatory and optional under the Indian Registration Act 1998. In the case of immovable property, if there is any transformation at any point of time whose subject value exceeds the rupees 100, if it is rupees, whether exceeds the rupees 100 means it's more than 100. Am I right?
Yes, sir.
The registration is mandatory under the Indian Registration Act. See, it is showing the red color underline. Do you know why it is showing?
R should be capital and
No. We never say registration, the registration.
yes, sir.
So we remove the THE. The is a definite article or indefinite article?
Definite article, sir.
I appreciate. Sir, are you teaching the law, sir? Are you teaching the grammar? It is a combination of everything. Because when you write in a Professor Hussain style. Speak in a Professor Hussain style. Even a comma, full stop, underline, everything. So registration is the mandatory under the Indian Registration Act 1998. And next, the mobile property, next bullet is small bullet is, the mobile property is liable to be sale tax. Tax, central tax. Though subject to a certain restriction under the, of course, at the time, Andhra Pradesh was there. Now, Telangana state or Andhra Pradesh state or common state, wherever it is there. So now, all this sale tax, central tax is completely no more now. Then what is there?
GST, sir.
What is GST?
Government sales tax.
Are you right?
Government service tax.
Yes, anyone?
Government service tax.
Okay, why the doubt? What is GST full form? It now will give. Yes, read.
Goods and service tax.
The full form of GST is Goods and Service Tax. GST is a single indirect tax levied by the Indian government. Now, in the abbreviation, in which category GST comes? I told you 4 categories of the abbreviations.
Initialism, sir.
Initially, why you are taking so much time? Because you are taking each word as an independent word.
Yes, sir.
So we should say initialism. Only Professor Hussain students will say like that. It's an open challenge to anyone. Okay, now let us come to the next point here is the mobile property is liable to sell tax, as I told you, and now the GST is there, and hence where the immobile property is not liable to sell tax, but stamp duty and registration fee have to be paid under the respective acts. Now, I don't know, even a Taisil, Mandal Revenue Officer, MRO, can also register
No, sir.
because certain time they have given the power.
No, sir. There is separate office is
Acha,
there,
there
sir.
is.
Sub-register office, and there will be one authority, competent authority. He has only power to register, sir.
Suppose if I am selling the agriculture land, whether the registration at the revenue department should be there or registration at the buildings are there.
No, sir. For registration purpose, and Indian registration
And
under Registration Act, sir, only register and
yeah,
register
the
is
break
the
of voice is
competent
there. Okay,
authority
doesn't
to
matter. Let doesn't matter.
register.
Let me do it. Generally, the registration office either to the open plot or to the building. Okay, now let us see that how it can be there. In the case of the mobile property, the transfer is complete when there is a mere delivery with the intention to transfer. Means a possession is enough. It is not the same in the case of the immobile property. In this case, the mere delivery with the intention does not constitute a valid transfer. The property transfer must be registered in the name of the transferee. Who is a transferee here? Salma. Who is a transferee here? The person who buys the property is called a transferee. Am I right?
Yes, sir.
Okay, now section 6 of the TPA 1882 says, just now we laid down the exception to the general rule, property and interest of the property forms as a general rule which is a transferable, and the transferability of the property is based on the maxim I told you, that the alienation preferitor jury accrescendi, which means law favor the alienation to accumulation. Means they prefer the alienation but not the accumulation. I give the explanation also. At the time the Gausia was not there. Why the law will prefer the alienation, but why disfavor the accumulation? Yes, sir. If you know it, you tell me. If you don't know it, say pass on. Don't waste the time.
The government will get revenue if transactions take place, sir.
Yeah, there is a stamp duty, there is a revenue, there is a registration. Revenue also comes from the government, hence they will always. And moreover, the property should not be accumulated at one place with the one person, two persons, because they become the government. Are you following me?
Yes, sir.
Good. Hence, it is stated that any action that are made to interfere with the power of the owner to alienate his interest in the property are not considered in favor of the law. Of course, they say certain interference with the power of the owner to alienate his interest in the property are not considered in favor of law, because generally something will not be come out. Of course, there is the interest, and there will not be perpetuity of the property. Only one, two, and the lifetime of another. Otherwise, property will be disposed automatically. Analysis. Yes, please. Do you want to ask anything? Shall I proceed?
Please proceed, sir.
Good, because I could have heard the sound, that's why I say. The main aim of the article is to provide the immobile property which are not transferable, and also differentiate between the properties to have the clear understanding, the concept. There is a section 6 of the Act states about the properties which are movable and not transferable also. The details analysis of the exceptions are summarized below. They are the immobile property, but not transferable. What are they? So in the section 6, clause A, how do you pronounce? Which I
Section 6,
highlighted.
class.
Repeat.
Colon, sir.
Spes succession. How do you pronounce?
Space succession.
That is the pronunciation. So this section states that first bullet, small bullet. See, when don't speak, unmute it, because I'm getting the sound. Rosia, when you don't speak, unmute it. Mute it. Yes, that is good. Yes, the first bullet is the chance of the heir apparent succeeding to an estate cannot be transferred. Even the chances of heir apparent means going to get it to an estate after the death of his father, because he is only the legal heir and cannot be transferred. Number one. Second bullet is the chance of relation obtaining a legacy on the death of the kinsman cannot be transferred. Of course, if the person Karta is still alive and he is not died, of course, after death, property will come under the mutation, and each one, the legal heirs get their own shares depending upon the personal law of the person who died. And then such a thing also cannot be transferred. Next, the last bullet is, read the last bullet. Unmute and read. Salma, are you there?
Yes, sir.
Read the last bullet. It's highlighted.
Any more possibility of a like nature cannot be transferred. Any
Yes.
mere possibility of a like nature.
Good. Now mute it. Yes, good. If you don't mute now, I will get the resound. So any mere possibility of like a nature cannot be transferred. They are going to get it. When they are going to get it, when? After the death of a person. So such thing cannot be transferred over there. You know what the people will do? They will kill the person to get the to get the to get the please speak.
Property.
Yes, why you are taking so much time? That's why they will not transfer such a property, even though it is a immobile property. What is the name? We use it. Section 6, Class A.
Space succession, sir.
Space succession. Yeah, that is the one. So explanation one, as he is the owner of the property, if he dies, his son B will get the property, and he is the legal heir, only legal heir. And here it can be said that B is the heir apparent, because heir apparent means he's only one legal heir, and obviously. But this same property cannot be transferred to B during the lifetime of A. Who is A?
Owner of property.
He is a father as well as the owner of the property. Am I right?
Sir.
C is a son, B is a son.
He is the son.
Then A is the father and A is the owner of the property. So, who is A means A is the owner of the property as well as the father also to B. So, that is the thing. Otherwise, what will B do? He will kill his father to get the property in the form of succession, and he want to sell it. That's the reason they say such succession that cannot be transferred, even though it is a immobile property. Explanation 2. Son B dies during the lifetime of his father A. Now you tell me. If during the lifetime of his father, he transferred the property without the father's consent, then the transfer would be void ab initio and is prohibited by law. Before the death of the B, can B transfer to somebody else? Answer is no. When he did not become a owner of the property, how could he will transfer? Is it clear? Say yes.
Yes, sir.
Good. So that is special section. Suppose if I want to sell the Taj Mahal, can anybody will buy it?
Even though they buy, it is not valid, sir.
Why it is not valid?
Because it is ownerless thing, sir.
It
not
is the endowment or the archaeological department. It is not Shah Jahan nor the progeny of Shah Jahan. Am I
Progeny
right?
means
You don't know what is progeny? Means issues of the Shah Jahan. Is it clear? Say yes.
yes, sir.
Good. So now it is divided. Section 6, Clause B, right of re-entry. This clause states that the right to resume the possession of the land, which could be given to some other person for a certain period, for example, lease cases. As per this, if there is a mere right of rewrite for the breach of a condition, it later cannot be transferred to anyone except the owner if the property is thereby affected. Can anyone transfer the lease property?
Yes, sir.
Can anyone sell the lease property? Yes, he can sell it. Can a lessee can sell the property?
Lessee cannot sell, sir. He can sublease only.
Even he cannot sublease when there is a clear provision is there. Is it clear?
Sir.
A delegate cannot delegate to another delegate. Hence, unless until it is clearly mentioned in the lease agreement. Example, A grants a lease of land to B for 3 years. Who are the lessee, who are the lessor and who are the lessee, Salma? Only 5 minutes are left. Who are the lessor and who are the lessee, Salma, in this case? In this example.
A lessor. B lessee.
A is the
Lessor.
and B is the
Lessee.
very good. Now mute it. At the expiry of the 3 years, if he transfer the right to of rewrite to C, then the transfer shall be invalid. If he transfer the right of rewrite to C, when after the expiry of the 3 years, he is no more a lease period, only the lessor can transfer it, but not the lessee. Rewrite to C. Of course, sometimes no, they will give the point. They take the lease, but he could not do so. They take the lease of land for agriculture, let us presume it. But he cannot having the money to buy the fertilizers, plowing, and transplantation of the plants, and weeding out. So he can also give to somebody else. But he can do so only within the 3 years. But after the expiry of the 3 years, he cannot do so because he is no more a lessee. Am I right?
Yes, sir.
So that is the meaning. At any time it can stop it. But let me continue at least section 6, clause C, easement. And we discussed at least 4 classes on the easement. And I don't think that I need the more explanation. I read it. An easement means the right that a owner of the occupier of a certain land in his position of his beneficial enjoyment of his land, he can be said that the right to use or restrict the use of the property of some other person. An easement cannot be transferred except the dominant heritage. Easement is not a right, except a dominant heritage is there. Only the dominant heritage means he can walk from the land of others to reach to his own land. Is it clear? Say yes.
Yes, sir.
So here example we have given is M, the owner of the house, has a right of way over the adjoining land with N. Hence M cannot transfer the right without transferring the house. He can transfer the right, but without transferring the house, he cannot do so. Am I right?
Yes, sir.
Yes, in the case of the Sital versus Delaney, the court held that an easement cannot be transferred unless the dominant heritage right is attached to it. When the dominant heritage is attached to it, then only can be transferred. Suppose unweaned calf, if you buy the cow, automatically unweaned calf also comes with the cow. ఆవు కొన్నాను అనుకోండి, ఆ దూడ ఉన్నది ఆవుకు, సో ఆవు దూడ రెండు వస్తాయి. Is it?
Unweaned means, sir?
Unweaned means which will not suckle the
Is not feeding from mother.
teats of the cow.
Feeding,
Yes.
taking feed from the mother.
Yeah. For the human being, we say nipple, breast. For the cow, what do you say? If you don't know, you say pass on.
Unweaned calf.
For the breast, woman is having. Cow, what is having?
Pass on, sir.
Udder. UDDER. UDDER, udder. And the nipples are called teats.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल गङ्गा विन्ध्य हिमाचल यमुना गङ्गा उच्छल जलधितरङ्गा तव शुभ नामे जागे तव शुभ आशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनितव उदार